we've had supervisors that will say, 35 plus 45 is actually 80. So you're not really due any overtime. Hour each week stands alone.
Which side are you on? Which side are you on?
Our next guests are going to be from the Department of Labor, the Wage and Hour Division. We have Christina Coleman Lovelace. She is more or less the outreach and, public relations kind of person for the DOL Wage and Hour Division. And Lindsay Arnold is the investigator for the DOL Wage and Hour Division in Huntsville. And we wanted to bring them on because most people have kind of a broad understanding of, hey, I'm supposed to be making at least $7.25 an hour. If I'm not a server. If I'm a server, I should be making at least $2 an hour, $2.13 an hour. And I should have, there are some overtime protections that I'm vaguely aware of, right? These are things that people have vague notions of, like, these are protected rights that I have in the law. But I don't think, even for myself, most people have a good understanding of actually what the law is and actually how to make sure it's enforced. We're a Union Talk radio show, and so one of our first things is that you should do a union about it and enforce it yourself. And that's, that is a tried and true method of getting higher wages, better benefits, overtime protections, things like that. But let's say you don't have a union, or let's say you don't want to wait for a campaign and, you feel like your rights are being violated now. What can you do about it? So we wanted to talk to them about it. Christina, Lindsay, thank you very much for taking the time today. I appreciate it.
Thank you for having us.
Absolutely, absolutely. So, Christina, tell us what the law is specifically as it relates to wage and hour. What are the things that workers in America, workers in Alabama, ought to expect when they work for an employer?
Well, we are the Wage and Hour Division. And one of the most broadest applications governing that particular act, of course, is the Fair Labor Standards Act. And that's governing minimum wage, overtime pay, youth employment. Outside of the Fair Labor Standards Act, we also pretty much enforce the Family Medical Leave Act, known as FMLA. We enforce the Migrant Seasonal Agriculture Worker Protection Act. Believe it or not, a lot of people don't know this, but we actually enforce the Employee Polygraph Act and the Wage Garnishment Provisions Act, as well as the Davis-Bacon and related acts, the McNair and O'Hara Service Contract Act, and of course the Temporary Worker and Provisions Act. So there's acts that we actually enforce, but one of the biggest, most common acts that we actually enforce is that minimum wage at that $7.25 an hour. Right now, that is the federal minimum wage. We have a lot of states that actually pay their employees more than that $7.25. But for the state of Alabama and every other state within the United States of America, we're just stating that that $7.25 is at the federal minimum wage. If a state decides to pay $10 an hour, or like California, $12 or $13, or DC at $15, that's at the state minimum wage. We're just saying that you can't go below that $7.25.
Right. And so then the states would be it would be their job to enforce the state minimum wage. Y'all are just going to be making sure that, people across the country are paying at least $7.25. And I think, especially in this economy, you hear a minimum wage of $7.25 an hour, and it is difficult, I think, for a lot of people to understand that this is actually an issue, and that law, the 725 law, actually does get violated still. Can you talk to us about that yes, people do still pay the minimum wage or below it?
Yes, they do. I mean, Lindsay can probably speak to you about that more, but not only that, Jacob, we have it set at $7.25 per hour, and I think that's been effective since 2009. And a lot of trainings that I do, I have to let them know that that's cash or equivalent, and that's free and clear, which means that you have to pay them in cash. You cannot pay them at $6 with a coupon, and $6 in cash, and $1.25 with a coupon to equal to the $7.25. There has been cases where people have actually paid someone $6 and would give them the $1.25 for a meal or something of that nature. So we're one of the ones that just are investigators, such as Lindsay, are one of the main ones that make sure that we enforce that $7.25 an hour. We make sure that we let all employees know. That doesn't speak for tipped credit or for tipped employees, because we do have those employees that you mentioned earlier that are paid federal law $2.13 an hour. But you have to say that you at least have, I think, make tips of at least $5.12 an hour to equal the $7.25 an hour. So you sometimes have a tipped credit where the manager or supervisor is basically stating that that employer is going to guarantee that they make that $5.13 or $5.12 an hour in tips. If they don't, they have to pay them that amount in tips to equal the $7.25. So the $2.13, which is low for a tipped employee, plus the $5.12 makes the $7.25 an hour. So we spend a lot of time, myself, educating and training a lot of companies on the laws that we enforce as it pertains to FLSA, as it pertains to FMLA. But one of the major components of the acts that we basically see a lot of violations in is the FLSA, which includes minimum wage, overtime. We see a lot of overtime issues, and even record keeping. And
yeah,
Lindsay speak on that later on.
Right. Well, and the tipped minimum wage, can you explain what the law actually is there? Because I'm not sure about it. I knew that that over the course of some period of time, the tipped minimum wage, you did have to make enough in tips to actually get up to $7.25. But what is that like? Do your weekly wages have to equal $7.25, or is it daily, or is it hourly? What is the actual? If I'm a server, because I remember being a server, and not making minimum wage on a slow Tuesday night. But over the course of a week, I would end up making more. But did I have a case there, having a slow Tuesday night, and I made $4 an hour for that? Did I have a case there?
I can have Lindsay to speak on that, because normally, and Lindsay more than likely back me up, I do know, as I stated before, that employers that are your tipped employees are paid at least that $2.13 an hour. But you can also claim a tipped credit for the rest of the minimum wage. So if you haven't been paid at least that $5.12 per hour, then you can actually claim a tip credit. Of course, in some states, they require more per hour in cash for those tipped employees, and that higher amount usually prevails in some of those situations. But also, if an employee is employed in concurrently with, I think, like a tipped and a non-tipped occupation, the tip credit can also still be available for those hours that you spent in a tipped occupation, such as a busboy, or in a duties related to a non-tipped position, such as a dishwasher. So a lot of those duties can be sort of incidental. So it could have been a situation that you were actually a waiter, and that's a tipped position at $2.13 an hour, but you could have also been working as a busboy, and that's a non-tip position. So you should have gotten a tip credit for anything under that $5.12 that you did not make. Am I not correct, Lindsay?
No, you are absolutely.
I was a server, and I was making. Yeah, I was a server, and I was making $2.13 an hour, and I was wondering what the timeline on that is. If every day or every hour, when does that actually come into effect? Because I remember
it's every week.
It's every week.
Every week. Mm-hmm.
Gotcha.
Yeah.
Okay.
Every work week stands alone. That's our saying in wage an hour.
Yeah.
Okay.
Which means that if you are for overtime, for example, if you worked 35 hours in week 1 and you worked 45 hours in week 2, most people are paid bi-weekly. So I've seen where we've had supervisors that will say, 35 35 plus 45 is actually 80. So you're really due any overtime. But hour each week stands alone. Week 1, you may not have received overtime, but that week 2, you were supposed to be due at least 5 hours of overtime. Just because 35 plus 45 equals 80, week 2, you were due that overtime of 5 hours.
Mm-hmm. Okay, yeah, let's talk about. Yeah, let's talk about overtime then. Who is actually eligible for overtime? Because I know that salaried employees, for some reason, companies are able to get around my understanding is that they can get around the overtime law and not have to pay overtime if the employee is salary. And so how do you, as an employee, know whether or not you are entitled to overtime, which is time and a half after 40 hours?
Okay, so actually, in order to be exempt from overtime, it's actually a two-pronged test. You have to make a salary that remains the same regardless of your hours worked. And starting January 1st of 2020, that salary amount increased from $455 a week to $684 a week. And again, that is remains the same regardless if you work 50 hours, 80 hours, 20 hours, that salary has to remain the same. And then the second part of the test to be exempt from overtime is a duties test. So either, there's 5 or 6 different ones, but essentially, if you are a supervisor, meaning you supervise 2 or more full-time employees, you hire, fire, you schedule, discipline, train, that would be one of the duties in which you would be, that would meet that exemption part or the duty part of that exemption test. Another one is there's computer. You're actually like a programmer. You're not an IT person. You are actually writing code, something like that. There's a couple little, differences with that particular computer exemption. We have professional exemptions for lawyers, doctors, teachers. We have administrative exemption, which covers employees that make decisions that affect the financial, outlook of the company. These, they're not, an administrative assistant is normally not going to qualify under that particular duties test. But administrative exemption is someone who is, entering into contracts of $1 million or buying stuff for the company with the company credit card without approval from, the big boss for $100,000 here or there. Those are the type of, people that really do affect the financial, outlook of the company. So those are some of the ways to be exempt from overtime. So it's not just that salary, it's also a duties, part of, in order to be exempt from overtime.
So you said it's a 2-pronged test. It's an and test, as in it's not enough just that you make this salary, and it's not enough just that you have these duties. You have to make at least this salary and have these duties.
Correct.
Gotcha. Okay, that's interesting. And so then, what about? I think we have we've got a better idea of who the overtime law applies to, and some of the minimum wage stuff. How do I, as a worker, go about enforcing this? If I feel like if I'm listening to this and I say I don't think that my position actually qualifies for the overtime position or for the overtime exemption, or I'm thinking that I'm not actually being paid $7.25 or they're giving me $6 in a coupon or something like this. How do I go about ensuring that this is enforced?
Well, actually, you'll reach out to our offices. We have an office in Huntsville, Montgomery, Mobile, and Birmingham. So if you have any indication that you feel that your rights have been violated, where you're not being paid the $7.25 an hour, where you feel that you're not being paid overtime at anything over 40 hours in a work week, you'll reach out to one of our offices. You'll come. You can either walk in, you can call us. We have people on staff from, I think it's 8 o'clock a.m. until 5 o'clock p.m. So feel free to contact us. Visit our website. Feel free to visit our website at www.dol.gov/WHD. And you can find any one of our offices throughout the country and our contact information to reach out to us. And you'll have someone, what we call a wage and hour technician, who will take your complaint. They'll make sure that they can forward it on to an investigator. They'll review the information and see if there has been one of your rights that have been violated.
How do I protect myself against retaliation? Because one of the things that we know as union organizers is that unionists are often actually retaliated against. Even though it is a federally protected right, it is illegal for employers to discipline workers for union support. It is illegal for them to fire workers for union support. It does happen. So what are the ways that I protect myself, that the government protects me from retaliation if I report my employer for overtime or wage violations?
Well, everything that we do is confidential. So when you come into our offices, we're not able to disclose who you are. You can come in, file your complaint, everything, and I have to stress, everything is confidential. We'll take down that information. We'll reach out to that employer. That employer will not know who you are. We're basically, and Lindsay can probably back me up on this because with her being an investigator, she knows the processes. But we, like I stated, everything that we do is confidential. When you come into our office, you file a complaint, you can call our number, you can say, hey, I believe that I've been discriminated against, or I believe that my violations have been violated, my rights have been violated, I haven't been paid overtime. We will ask for certain information, such as your pay stubs. We'll request other information from that employer, and the investigation process starts. And Lindsay can more than likely let you know what she does when she gets a complaint like that.
Yeah, absolutely. I mean, we pride ourselves on keeping everything confidential. When I do an interview of an employee, either at the establishment, I always go into I need a private space, usually an office, and I, tell the employee that this is, a federal investigation, but I do need you to be completely honest, and everything you say to me is confidential. We can't do our job, and we can't help people unless they come to us and let us know that there's a problem. So we have different types of cases, whether they're a complaint-driven case or a directed case. But a complaint case, is an employee coming to us and saying, hey, I'm not being paid overtime, I'm not being paid minimum wage. And we take their information, and everything will remain confidential throughout the investigation. There are a few instances where an employee allows us to use their name, and we do that. But even when I get, as an investigator, even when I get permission to use name by an employee, I very rarely do. It just, it just doesn't even, we don't even need that. We go in and we let them know, hey, we're investigating you, to the employer. And this is what I need. And they never know. And they want to know, is it a complaint? Is it a directed case? Why did it start? And I let them know that, unfortunately, that's something that I cannot tell you. So that's very, very important to us at Department of Labor, Wage and Hour Division, important to all of the investigators to keep that confidentiality.
Yeah, that's good. I think those are some good safeguards. What if the employer does have a pretty good idea? Maybe let's say that, most of his employees maybe are his family, and he has one person that's not his family, and that person is kind of not happy sometimes about his treatment or her treatment. And, there's some deduction going on, and the employer reckons that they know who it is, and they retaliate against the person, they fire them, or they threaten to do one of those things. What are some of the protections that they have in that case?
I mean, we have laws that essentially say no retaliation. The only issue with something in like that situation is it's hard to prove. Again, I will have employers say to me, well, this employee, I know for a fact this employee was the one that called you. And we still say, Mr. Employer, you have no idea whether we started this case as a complaint or a directed case to begin with. But 9 times out of 10, when they say, oh, I know it's this employee, they're wrong because it's somebody else. I also tell employees when I am, whether if it is a complainant, to not discuss calling us or complaining. If you have an issue with your employer, obviously, you want to go to the employer first maybe and discuss it. But don't go tell your coworkers, because 9 times out of 10, they're going to throw you under the bus, whether or not you deserve it. So keep all this information confidential with yourself and your peers at work as well. I feel like that's really, really good advice. If you do have a complaint and you do call us, you don't need to let everyone at your office know that you called us. Just kind of keep that to yourself. And I think that would help also with, kind of fighting off some of that retaliation that we all know is there. The only problem that I found working with wage and hour division is that, Alabama is an at-will state, meaning, they can fire you for having your shoe untied. And they can say, your shoe's untied, I'm firing you, when you and I both know that the reason that they're being fired is for allegedly, complaining. So we try really, really hard to protect our employees, the workers. We do have laws that, protect employees against retaliation as well. It's just, we have to be very, very careful in an at-will state like Alabama.
Would that be if I wanted to try to move towards enforcement on, my employer retaliated against me? Would that be like an unfair labor practice with the NLRB, or would that be something that the DOL would handle?
We have the Christina, correct me if I'm wrong. Is it the 216? The FLSA? Is that right?
Yes,
okay.
But
so we actually have retaliation laws that when I send out for example, I just sent out an initial conference packet to an employer. In that packet, I include our fact sheet on retaliation, which says you cannot retaliate against any employee for talking to us, complaining, and it gives all the, in simple terms, it gives, the facts of that law, and I send that out with every packet to every employer that I investigate. Hoping to kind of, once they read over that and they see that there is a law against retaliating, that hopefully will steer them in the right direction of not retaliating.
And we also work with other agencies as well. So just in case there could be a situation where our agency does not enforce a particular law, we work with other agencies such as EEOC, the Equal Employment Opportunity Commission, because it could be a situation dealing with some type of job discrimination based on age, based on race, based on sex, based on disability retaliation, because EEOC does have a Retaliation Act. So a lot of times it could be a situation that it may cross over into another agency's enforcement or jurisdiction. So sometimes what we'll do, we'll forward that particular case, if it's not within our jurisdiction, to agencies such as the Equal Employment Opportunity Commission or OSHA or the IRS or things of that nature. If it's pertaining to a particular job, that we feel that it could be something based on disparate treatment or disparate impact.
Right. That's good to know. And that's, I think, an important thing to take from this, listener, as far as protecting yourself from retaliation is, like they said, keep it confidential between yourself, as much as you can, unless this is part of a union campaign or something like that, where this is a deliberated strategy. But also document. Okay, if you have, if you need everything that you can to prove that if you're actually going to try to enforce the law as far as protecting yourself against retaliation, if you're or enforcing the law after you've been retaliated against this, the thing that you have to do, right, is prove that is why they fired you. So you need to, conversations with your boss, record them. Alabama's a one-party consent state. You don't need their permission to record them. Document your text messages, your emails, have your employee handbook, all of these things, other disciplinary measures that other people have had. See what's been consistent. Document. That will that'll kind of CYA in these types of situations. So, Lindsay, you're the investigator for Huntsville. Talk to us about your the things that you have been able to accomplish as an investigator in Huntsville. Some of the, like, how in an average in a certain amount of time, how much are you generally able to win for to get back for workers?
Well, of course, every case is different, so it just depends. I just recently completed some minimum wage investigation for the Jefferson's restaurants, and there were 5 total restaurants: Albertville, Hoover. There's like 4 in Alabama and 1 in Georgia, and there were essentially, when an employee takes a break of less than 20 minutes, the federal law considers that compensable hours worked, meaning that it needs to be paid time. Although the federal law does not require lunch or coffee breaks, if the employer gives them or offers those breaks, they need to be paid if they're less than 20 minutes. So looking at records and interviewing employees, I found that there were that these employees were not paid for all their hours worked because these breaks of less than 20 minutes were deducted. So 5 establishments, 343 total employees were due minimum wage back wages of $184,152.20. So again, talking a little bit about the tipped employees that we were talking about earlier, a tipped employee is a minimum wage employee. So regardless, like if they get that $213 from the employer, right? And then they're supposed to get $512 or above from the customers, and then the employer takes that credit for, even if they make, let's say they make $100 an hour with their tips. This is like some fancy restaurant that they, make a lot of money. They are still considered a minimum wage employee, regardless of that $512 or if it's $1512 or whatever it is. They are always considered a minimum wage employee. And so because of that, we had these illegally deducted breaks from these restaurants, and we got over $184,000 to these employees. And so I feel like that was a good, it took a little bit of time, but it was a good investigation. And it was, honestly, kind of face of the record violations as well, because I could see the breaks deducted when they gave me the records. So.
Yeah, that's really great. And that's I think that's a good example of the law working for folks. And presumably, we don't know whether that was complaint driven or otherwise. But has there been any retaliation in that case against any employees?
No, sir. Not that I'm aware of, at least.
Yeah, and I'm sure if these employees have been seeing you and knowing that you're a kind of a wage and hour enforcer, they'd be letting you know. So I think that's a good report.
Yes, I get calls all the time. I'm one of the investigators that I give out my, it's my work cell phone, but I get calls all the time from former employees, former employers saying, hey, Lindsay, I'm thinking of changing this person's pay from hourly to salary, and how we talked about earlier, would they qualify as an exempt employee? And, I tell my employers when I'm done investigating, I say, hey, listen, if you have questions in the future, you call me, email me, let me know. I would rather spend an hour on the phone with you, helping you out, making sure you're in compliance with our laws, then we do another investigation, because, they take time, and I would rather, make sure that those employees are paid properly from the get-go versus kind of going back, which is what we have to do for most of our investigation is we go back in the past. We go back, for a 2-year statute of limitations. So.
Right.
And Jacob, let me interject with what piggyback off of Lindsay. Our main thing that we want to pretty much get across is compliance. We want to make sure that everyone is compliant. We're not going around pointing the finger at them and telling them what they're not doing right. And we're just wanting to come over and investigate you and get you in trouble. We really want them to be in compliance. That's why my position was created over 11 years ago, so that I can get out. I'm not an investigator. I'm the public face of everything, and let them know when you don't understand, that's okay. Reach out to us. Let us help you understand, because we're not trying to change the way that you act. We're trying to change the way that you think. If we could change the way that you think about compliance, it automatically will change the way that you act when it comes to your employees. And that's what's most important, at least to me, is the education, the training, and the compliance piece to make sure that you're in compliance with our laws. Like I stated, everything we make sure that when I go out, I give out fact sheets. We give out website addresses. We give our telephone numbers. I give out my cell phone number, my email address, and I'm making sure, hey, if you have any questions, call us. Don't just assume that you know what the answer is going to be. Please reach out to us so that we can assist you in making sure that you make those right decisions, so that we don't have investigators coming to you, because what we do is public. It's no longer private. So if it's a really big case, like the case with Jefferson Restaurant that Lindsay was talking about, that just went into a press release. So it just made it's public now, and that can mess with the company's brand. And so now everyone will know that you violated someone's rights as it pertains to minimum wage, record keeping, overtime. And then you may have another agency such as the IRS that feels that, okay, if they can violate wage and hour, I wonder what they're doing under IRS. And then you have EEOC. If they can violate, wage and hour, I wonder if they're violating Title VII of the Civil Rights Act. I wonder how many people that within a protected class that could be disabled, or someone who could be all female, that they're not actually giving them raises. So it could be a snowball effect that if you would have just reached out to one of us, picked up the phone and just asked a question, am I in compliance with the law as it pertains to FLSA, wage and hour?
I think that's a great message. I don't think that many employers listen to our show, frankly. But if anyone is, maybe they're doing opposition research. Please reach out to the Wage and Hour Division. If you have questions, or like you think you're clear on something, but you know that you don't know 100%, sounds like you should probably reach out to these ladies, because they'll try to help you out and save you some trouble. And I did want to clarify something that I believe you mentioned earlier, Lindsay. You talked about the different types of investigations. There's those that are brought forward by a complaint. What was the other one?
The other one is a directed case.
Okay.
Sometimes we do, we're looking for, we found some issues with a certain type of employer. All the laundromats in Huntsville. Okay, let's say we're noticing a pattern. They're not paying their people right. So there are times where we'll go in and go look for that. It just depends. And again, those decisions are made way above my head. So not something, I just kind of get assigned. And as I tell employers, it doesn't matter to me if it's a complaint or a directed case. I treat them all the same. I go in there and I, ask for records, and I interview employees, and they're exactly the same to me as an investigator. But that's the other type.
Okay.
And that actually comes from research that me, actually, a lot of my colleagues, just as me, we do a lot of research on different trends, and we do analysis based off of the Bureau of Labor Statistics. And I look at different trends that happen within a particular industry based on how many times that they violated the law as it pertains to minimum wage or overtime or record keeping. And then we'll look at the trends. And then, of course, I'll submit that information to our district director. And from there, we'll decide on, okay, in this particular industry, we're always seeing a trend in nail salons or in restaurants, or we're always seeing in the recreational industry that there's always a trend as it pertains to child labor. We may need to look into this particular industry to see how we can combat that program, that issue, try to see how we can make sure that they understand about child labor and the violations as it pertains to child labor.
That's awesome. Yeah, thank you for sharing that, because I wasn't clear on kind of how that worked. And one thing I wanted to follow up on as well, and Jacob mentioned document. Absolutely echo that sentiment. So if I am a worker and I believe I have one of these issues, whether it's overtime or minimum wage or something else, what is the advice you could give to me in terms of how to help you help me? How can I, as the person with the complaint, make your job easier to investigate and ultimately be successful and get the issue resolved?
Record keeping. Record keeping is one of the biggest things. We even in our agency, we created, it's a calendar, work hours. It looks like a little checkbook ledger. And it has your start time, your stop time. It has all the information that you can actually write it down and keep it in your pocket. And you can write down the time you came into work, the time that you stopped, the time you took a lunch break, any issue as it pertains, because a lot of companies, we see a lot of off the clock work.
Yeah.
We see a lot of issues where your employer, you're not supposed to be to start work until 8 o'clock. But some employers have you come in and work an hour before, start working at 7, whether you're working in a restaurant and you're folding up napkins, or you're taking out the trash, or you're doing pre-work type of things, and you're not being paid. That's considered off the clock work. And you have a lot of employers who will have you to not clock in until 8 o'clock, even though you've been there since 7 or 6 or 6:30 actually doing work. So you're actually due an hour and a half wages. But they'll have, that's what we call off the clock work. And that's another violation as well.
I'm glad you brought off the clock work up, because that's something that I personally, witnessed quite a bit as a labor representative. And, obviously I encourage workers to not do that. You should get paid for what you're doing. But I get it. Sometimes folks are pressured. You're in a kitchen and the manager is monitoring the labor hours. You're not supposed to clock in till 8. Yep. But, there's stuff that's got to be done so that you can actually get the food cooked on time. Or at the end of the shift, you've clocked out, but then suddenly they remember, oh, yeah, you didn't clean that bathroom, or whatever it may be. So these issues do happen a lot. I'm sure folks listening have experienced them themselves. I hope that folks have gotten some good information here from both of you. And I guess my last question would be, and this is to either one of you, what's something that you think workers don't know that they really should? Something in the course of your work that you maybe you're surprised by it, or something that comes up all over and over, something that you could share with our listeners and hopefully address that.
Well, with me as a trainer, I'm sorry, go ahead, Lindsay. With me as a trainer, I'm really shocked at how a lot of people don't understand their rights. You would be really shocked with the number of people that really don't understand the minimum wage is, that really don't understand that they're due overtime, that really don't understand that they have a right to keep up with the hours that they worked. I've seen situations when I've done trainings and I've had employees to come up to me and I pretty much stress to them, oh my gosh, you need to come into our office and file a complaint. Because there was one situation where this young man, worked for a reputable pizza company here in Birmingham, and he didn't drink tea or soda. He only drank water. And what he was doing is he was using the soda fountain to get water out of the soda machine, and they were deducting out money for him using the soda machine, and it was putting him below the federal minimum wage. So he was only being paid $7.50 an hour, but that employer was deducting him 50 cents an hour just to use the soda machine, and he didn't drink. He was actually getting water. And it put him well below the federal minimum wage of $7.25 an hour. And once we deducted that out, and I calculated it, he was only really being paid like $7.10 an hour or something like that. And I asked him, I almost begged him to come into our office just to file a complaint. And I asked him how long had the employer been doing this? And he said about 8 months. But he was so afraid to come in and file a complaint because he thought that if he did, he would lose his job. Mm-hmm. And you see a lot of that. Well, people are just afraid, especially in this atmosphere right now. They're afraid. And this was actually about 5 years ago. And he never did come into the office to file a complaint. And sometimes you just, you lose one. You pretty much lose them. You can't make anyone come into the office and file a complaint. You can only stress to them that this is your right. This is money that you should not have been deducted. You are paid well below the federal minimum wage, and that's a violation of the law.
Right.
You win some, you lose some. So,
yeah. Christina, Lindsay, thank y'all so much for taking the time. I really appreciate it.
Absolutely.
Thank you for inviting us.
Yeah.
Thank you so much.
All right. Yeah, so we'll I think that will go on the show this Saturday. So
awesome.
we had another change in another person change their availability, so we are going to I told y'all that maybe it wouldn't go out this Saturday, but I think it will. So, and I'll let y'all know. I'll send you all the links and stuff when it goes out. So,
Thank you.
All right.
Yeah, thanks again for joining us and for being so patient and generous with your time. And I'm hoping folks learned a lot from this. I took notes. I learned.
Yeah, yeah, and keep us. You mentioned something about press releases. Let us know.
We'd love to see those.
Put us in your press list or whatever. We'd love to toot your horns for you. So.
Yeah, next time you win another six figures, we want to hear about that.
We actually get that all the time, so I can forward a lot of because they come to me, so I can get a lot of within the Southeast region. I think you're probably more so interested just in Alabama. So whenever we do a press release and there's, hundreds of thousands of dollars, I'll send that over to you guys so that you can.
Oh, for sure.
Please do. That'd be fantastic.
Have a copy of it.
Yeah.
All right. Well, thank y'all so much. I appreciate it.
Thank you.
Have a good night, y'all.
Y'all have a good one.
Bye.
Bye.
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.